Hello again, hope you're all doing well. Today's case has no connection to the 80s schlock hit Silent Night, Deadly Night Part 2, except for this meme.
Garbage day! Huh? No!
Which became a worldwide thing with people doing their own variations. You had St. Patrick's Day, Valentine's Day, yesterday. You had to be alive in 2008 to get it. But the connection between this meme and today's case is garbage. That's it. It's a Rule 23, and I don't know why, because I can't find another case that addresses whether a judge can sanction a party under Rule 219 for bypassing the tools of discovery and engaging in illegal self-help. You know, every other instance of 219 that I see is either for violating a discovery order or procedure. Now, when I did trial work, invasions of privacy for gathering dramatical information happened quite a lot, actually. You know, you had parents hacking each other's accounts, installing cameras or secret audio, you name it. So this case is pretty darn important, especially for those that do family law. But let me take a second to address colleagues who feel these videos aren't in keeping with the profession. In all seriousness, I get where they're coming from. So why do I do this or this? Well, to be honest, you know, these books might as well be written in Greek if you're a non-lawyer. Now here's an email from a parent I got about 10 months ago. The case was out of Crawford County. They'd been following this channel for a while, and they wrote me a very simple thank you. Couldn't afford a lawyer, legal aid was a no-go, and they watched my channel, and apparently it helped. These videos are for everybody, and if this offends your sensibilities as to what a lawyer should be saying or doing, I encourage you, plead with you, exercise this outrage by donating time to CVLS, Prairie State Legal Aid, Land of Lincoln, or any other legal aid charity. And that's all I'm going to say about it. So let's just get to the case here. There's a nasty maintenance fight, and here's my opinion because the decision didn't answer all of my questions I had as to what was really going on. So I have to guess some of this. The ex-wife had a credit card that she was an authorized user for. Her father was the one paying the card each month, and this allowed her to live a lifestyle that was a bit higher than what her bank records suggest. Meanwhile, the ex-husband wants to lower his maintenance payments, but he's having a hard time finding good facts to justify it. So he sneaks to her property in the middle of the night and goes through her trash. And the opinion indicates he went through her trash multiple times in the summer and fall of 2019 and found, well, all sorts of goodies, including a Capital One credit card statement. For whatever reason, he decides to sit on this information and has his lawyer issue a Rule 214. For non-lawyers, a 214 is a request for the other side to tender over documents, for example, copies of a Capital One credit card account. And this is a little bit different than a subpoena, which the ex-husband's lawyer also issued. If you want to know more about these, I got over 150 videos on this page, so feel free to go on a Netflix binge. Now, curiously, all this discovery isn't initiated until after proofs had closed on his motion to modify maintenance. I don't know why they waited till that point to start preparing for their case, but be that as it may, the ex-wife tries to quash this, which she is unsuccessful at. And at that hearing on the motion to quash, the ex-husband and his lawyer, they don't tell the judge how they know there's a Capital One credit card account. And while this is going on, the parties also try a settlement conference where the ex-husband's lawyer, who I guess has been watching a few Law and Order episodes, hadn't gotten the subpoena back yet, but had the trash statements, and he's like playing really coy and asking the wife about specific charges on the Capital One account that officially hadn't been turned over yet. Yeah, so I'm guessing at this point the ex-wife's radar is totally up and realizes that somehow the ex-husband knows about the secret credit card account. So the situation is going like full Telemundo. And it seems the ex-wife's initial theory is that the ex-husband's lawyer hired Hackerman. Tell me someone out there has seen Kung Fury. Anyway, she believed the ex-husband hired Hackerman to hack into her father's statements. So the ex-wife's father reports the ex-husband's lawyer to the ARDC under the Hackerman theory. So this results in the ex-wife filing Rule 219 sanctions against the ex-husband in the family case, arguing they already had the statements before they sought the subpoena or issued the Rule 214, and they attached that ARDC response as proof and believed this duplicitous discovery issuance was just to harass her. It's at the sanctions hearing that the truth finally comes out. The ex-husband admits he got the statements from her trash. What made this a million times worse, in my opinion, is that he gives the court an incredible in the classic Latin sense, explanation for his actions. Namely that, one, the judge secretly told him it was okay to do this. And 2, the police told him it was legal to go through the trash. And I say worse because the judge is like, a year ago when we did this motion to quash, somebody could have told me about this. We wasted a full year. I'm going to issue the sanctions and enters an order for the ex-husband to pay the ex-wife's attorney fees incurred from this drama. Now, no surprise, the ex-husband appeals this and the increased award of maintenance. Now, we didn't talk about that part because the record never made it to the appellate court, or at least the full record. And what little did make it over, according to the decision, cuts against the ex-husband's claim. And FYI, the responsibility for making sure the full record gets over is solely on us, the person appealing this. So worse, though, the appellate brief was, I don't really know a nice way to say this. I'm sorry. It was so deficient. It resulted in forfeiture of the argument on sanctions. And this happened because the argument section of the brief failed to include sufficient citations to the record. Now, let's be fair here. If we tore down every lawyer that made a mistake, we'd have no lawyers.
Can you imagine a world without lawyers?
But at the same time, some mistakes are a little bit more avoidable than others. So let's not kick this lawyer while he's down. Instead, let's ask ourselves, how can we avoid this in future appeals? If you see this, if you're a lawyer who doesn't do appeals and you're not sure what to do, just reach out to a colleague who does. There's no point in guessing at your client's expense. Yes, on occasion, I do wear regular clothes. Now, you may have noticed I spent a lot of time on the facts of this case, and there's a method to the madness, and it has to do with what this case is. It's a Rule 23. Now, Rule 23s issued in 2021 or later are citable, but only for persuasive purposes, like a legal treatise. Contrast that with a regular opinion, which is binding and has the same force of law as a statute. Now, all that said, for those wondering, can you sanction someone for invading your privacy when they could have instead used the tools of discovery the Illinois Supreme Court provides? Well, the answer is yes. But, and there's always a but, because it's a Rule 23, I feel the facts of today's case demonstrate just how nuts things have to get before a judge may feel comfortable issuing those sanctions under that rule. So litigators, litigate accordingly. Anyway, that's all I have for today. I'm going to be on a bit of a short break as I work on the shooting studio here and a few other things, but I return in June. I haven't picked out the next case yet, but if you have suggestions, let me know. That said, like the practice of law, being on this platform is a privilege, not a right. So thank you for your support. That's all I have.